Jason, the contracting officer, and Charlie, the contractor, are in a dispute about whether Charlie's company should be reimbursed expenses incurred when he removed a rock while installing a running track as part of his government contract. Removal of this rock was not specifically described in his contract, and the government asked Charlie to remove the rock, and that's why Charlie believes it's his right to be reimbursed the $100,641 that his company spent removing the rock. So Charlie decides to officially ask the government for reimbursement for his expenses. There are two separate paths Charlie can take to ask for this reimbursement. Charlie can submit a claim, or Charlie can submit a request for equitable adjustment, also known as an REA. In this training module, Jason will identify objectives, meet timelines, and follow the procedures generally used to process both a claim and a request for equitable adjustment. Claims and REAs are very similar, both in their nature and in the process contracting officers handle them. Since Jason needs to know how to process them, he first learns some of the fundamental differences between the two. Even though he might not know exactly what the differences mean right away, it will become clear when he begins to process his claim and REA. Jason finds 5 fundamental differences between claims and REAs. The first, obviously, the names are different. One is called a claim, and one is called a request for equitable adjustment. Second, for claims, the contracting officer's decision must be issued within 60 days, or as soon as possible after 60 days, depending on the aggregate dollar amount of the claim. For REAs, the Federal Acquisition Regulation, or FAR, only states, contracting officers shall negotiate equitable adjustments resulting from change orders in the shortest practicable time. There is no specific timeline that contracting officers are required to respond to an REA. The third fundamental difference between a claim and an REA is that they both require good faith certifications over certain dollar amounts, but the certifications are different. The claim's good faith certification is located at FAR 33.207C. And the REA good faith certification is located at DFARS 252.243-7002 and has fewer words than the claims certification. The fourth difference is that the certification statement for claims is required above $100,000, and the certification statement for REAs is required above the simplified acquisition threshold. And the fifth fundamental difference is that interest begins to accrue when the contracting officer receives a claim, but not when he receives a non-claim request for contractual relief. Jason knows there are a few other differences between claims and REAs, but appreciates how knowing these quick ways of distinguishing between the two will help him in the future. Since Jason and Charlie were unable to resolve their dispute by mutual agreement, Charlie submits his claim, or request for equitable adjustment, to the contracting officer, Jason. Jason is thrilled to hear the good news. The contracting officer's objective when handling a claim or REA is to 1. Resolve all issues in dispute. 2. To handle them in an impartial and unbiased manner. And 3. To efficiently and accurately issue decisions with a sound legal basis. Claims and REAs are both written demands for payment of money or other relief related to a contract. Both of the requests for relief must be submitted in writing. The claim process is a time-sensitive and a potentially interest-bearing dispute resolution technique. For this reason, the central focus point of this training module will describe how Jason resolves his dispute processing a claim. The REA process is the less formal of the two methods of resolving a dispute. So the REA content is available for you to access if you want by clicking where you see this big button. Now that Jason has received the claim, the first thing he does is notify his supervisor, his technical team, and his legal representative. Jason will hold a meeting with all of them, but before he does, Jason takes 5 preliminary steps to prepare for the meeting. The steps are: first, Jason reviews the contract and reads the applicable regulations and guidance. Jason will look for clauses which may be used as the authority to make any changes or modifications to the contract if necessary. Then Jason will read the regulations and guidance. Claims follow the Contract Disputes Act of 1978 as implemented at FAR Part 33. Second, Jason reviews the claim to ensure it's timely, certified, and signed by an agent of the company authorized to submit claims. Contractor claims must be submitted in writing to the contracting officer for a decision within 6 years after accrual of a claim. Third, Jason ensures the certification is included if required. A certification is required on a claim if the absolute value of the claim is over $100,000. Absolute value is the amount of any additions and/or subtractions of the claim's value combined together. The written demand for payment of monies above $100,000 is not officially a claim until it's certified. If a contractor submitted an uncertified claim exceeding $100,000, Jason would notify the contractor, in writing, of their failure to certify the claim and that the contracting officer's decision will not be issued until the claim is certified. Fourth, Jason reviews the proposal to make sure it's complete and that all the cost and prices are included and calculated correctly. Jason checks to make sure all elements of the proposal are present, including company name, clear descriptions of any changed work, and any other work elements affected by the work effort being claimed. Jason also verifies the work being claimed was attributable to the contract, any cost or pricing information concerns, correct calculations, and that the submission was from a duly authorized agent of the company. Jason also watches closely to ensure the proposal is free from any misrepresentations. And the fifth preliminary step Jason will take is to ensure the cost and pricing data, or other than cost and pricing data, is received as necessary. Cost and pricing data and other than cost and pricing data come in forms of receipts, paid invoices, or other data reasonably required to explain the contractor's expenses. Jason will use these to justify prices are fair, reasonable, and attributable to the work that is being claimed. These documents, plus the contractor's original proposal, can be analyzed for any necessary upward or downward price adjustments. Now that Jason has a complete package and a clear understanding of what the contractor is claiming, he calls his team together for a meeting. In the meeting, they begin to review the documents and the steps necessary to process the claim. Jason holds a fact-finding session with his technical and legal team. Jason verifies that this work was required, completed, and approved. As the fact-finding session continues, Jason keeps good notes, which he will later use to compose a memorandum for record about the relevant details leading to the claim and to compose a determinations and findings justifying any contract actions he may take. He also asks the technical users and the contracting officer representative to send him their perspectives about the events that occurred which resulted in the claim. Jason also addresses that this was an unauthorized commitment and reiterates that the contracting officer is the only person authorized to make any changes to the contract or obligate government funds. He and his supervisor will handle the unauthorized commitment issue separately. Then, the team performs cost or price analysis on the contractor's proposal. Jason works closely with the technical team to accomplish an analysis of the contractor's proposal, ensuring all team members are aware of what is being claimed and that they have the opportunity to have input about what the contractor is claiming. The team decides what costs are allowable, allocable, and reasonable to the work effort being claimed. There may be upward and downward adjustments as a result of a good analysis. Request additional field pricing support if necessary. Next, Jason and the team will determine the government's pre-negotiation objective. Jason and the team perform cost or price analysis on Charlie's proposal to derive the government's pre-negotiation objective. They will need to be responsive to all parts of the claim so that they can segregate each cost element and decide which elements to approve or deny. The government team may approve all of Charlie's claim, a portion of it, or none of it. They will derive their negotiation objectives based on their research, findings, and assessment of the situation. With the help of the technical team, Jason decides to approve the large crane with an operator, $6,000, the 5 workers which maneuvered and helped remove the rock, $3,600, and disapproves the stopped work employees, his cousin Ramon's expenses, and finally, since Charlie lost his receipt for the candy bar, Jason dismisses the cost. Jason establishes the government's negotiation objective is $9,600 and goes in to negotiate with Charlie. Next, Jason and Charlie conduct negotiations. Jason holds a negotiation meeting with Charlie and spends time explaining why he's not willing or able to reimburse some of Charlie's expenses, such as his cousin Ramon's private jet ride from Italy. Charlie accepts the government's position and agrees that $9,600 will resolve the dispute. If a mutually satisfactory settlement cannot be negotiated, Jason will issue his contracting officer's decision approving what the parties have agreed upon and then notify Charlie that they may appeal the unapproved portions of the decision. Jason then accomplishes the large part of the paperwork, including a price negotiation memorandum, a determinations and findings, a contracting officer's decision. Jason's contracting officer's decision includes all the requirements at FAR 33.211. For claims of $100,000 or less, the contracting officer shall issue a final decision within 60 days of receipt of the claim. Any certified claim over $100,000, the contracting officer has 60 days to issue a final decision or to notify the contractor of the date by which the decision will be made. A contract modification. In this case, Jason plans to issue bilateral contract modification to formalize the terms of the negotiation. And finally, Jason composes a statement of release, which will be signed by Charlie. This statement of release ensures the terms of the claim are agreeable in totality to both parties and that they have resolved all the issues relating to the dispute. With all the hard work behind them, Jason receives the required government approvals and clearances and then sends Charlie the modification and statement of release for signature. Charlie signs and returns the documents to Jason. Then, Jason finalizes the modification with his signature. In summary, Jason accomplished the following tasks. 1. Received the claim or request for equitable adjustment. 2. Received the proposal. 3. Verified the certification of good faith. 4. Conducted cost and/or price analysis. 5. Hosted a fact-finding session. 6. Analyzed the contractor's proposal. 7. Developed the government's pre-negotiation objective. 8. Conducted negotiations. 9. Wrote a price negotiation memorandum, PNM. 10. Wrote a determinations and findings, D&F, memorandum. 11. Issued a contracting officer's decision. 12. Received all the required government approvals and clearances. 13. Composed and received a signed contract modification. 14. And composed and received a signed statement of release. Jason knows each situation is different, but these are the general steps to resolve claims and/or REAs. Jason and Charlie may also use alternate dispute resolution to resolve their dispute and settle their claim. We'll take a look at alternate dispute resolution in the next module.